All right. The motorist is going to see 4 different kinds of sworn reports served upon them, maybe depending on the circumstances. And as the prosecutor, they need to be able to recognize these and to know what is applicable and what applies. The different kinds of sworn reports they may see, and for purposes today only, are statutory summary suspension and DUI. We're not talking about zero tolerance under 11501.8. We're not talking about accidents, injuries, no DUI under 11501.6. What we're talking about is strictly DUI statutory summary suspension sworn reports. You may see 4. You're going to have one where the breath test is 08 or greater, and that would require immediate service. The next one may be a refusal, where the motorist refuses all testing. That would be immediate service. It would be blood. That would be mailing or personal service once it comes back from the lab, or urine, mailing or personal service once it comes back from the lab. The first sworn report in here that in fact we talk about is an actual sworn report from St. Charles, Illinois, and a client of mine, where in fact you can see in the middle of the page the officer crosses, marks off, because you submitted to a breath test under 1150.2, an alcohol concentration of 2.30. That, and everything else is filled out properly, is in fact a valid sworn report that you would have seen from the police officer on a breath test. One small problem. When the defendant came in, they raised the issue of that there had in fact not been any box above the officer's signature marked, whether it was immediate notice or whether in fact they were mailed. Other than that, this was a valid sworn report. Now, the defense attorney may come in on a motion to strike and dismiss this statutory summary suspension for no box being marked. In and of itself, from a prosecutor's standpoint, you need to talk to the police officer, because in and of itself, that does not make this sworn report fatally defective. If you go to the police officer, you ask the police officer, in fact, did you serve the sworn report and did you forget about it? On the first court date where the officer's present, you can make a motion to amend, and that would cure any of this under People v. Donnelly. So the fact that the box, whether it's personal service or mailed immediately, is not fatally defective if the officer can truthfully testify they did serve it and they just forgot to mark the box. The next one, from Sandwich, DeKalb County, is an actual sworn report, and on it you will see where the officer actually marked because the individual refused. Valid sworn report. On the bottom of this you will see where the officer in fact, again, the officer marked everything off, signed it, Sandwich Police Department, badge 208 on July 22nd, 2012. This is what a refusal sworn report will look like. Now the next ones, where I see where from prosecutor's standpoint and from the defense standpoint there are a lot more issues, is when there are blood or urine results. In this one, this was a blood case out of DeKalb County. You look at the arrest date, April 19th, 2012. Happy birthday to me. The refusal or test date was April 19th, 2012. And then over here, you look on the left where it says notice of summary suspension revocation date given on the same date of the arrest and the refusal. When you see that, from the defense perspective, you're going to file a motion to strike and dismiss, because there's no way that the blood test came back the same day of the arrest. From the prosecutor's perspective, what do? There isn't a whole lot you can do. You may, your office policy may be, well, let's try to clean this up. Let's do this, let's do that. I see a lot of prosecutors trying to do things that is borderline, not right. And remember, you are a lawyer first, and you are also a prosecutor second. So you can't remedy this. In this case, it couldn't be remedied when, in fact, they show that the notice of summary suspension was given on the same date. Not possible, because it was a blood test. So then you further look at this sworn report on the blood, and again, the officer marks a .088, but doesn't mark the box as to whether it was an alcohol concentration or a drug result. You then look at the rest of this sworn report from the defense perspective. On the bottom left, above the officer's signature, did he serve? He didn't mark it. Didn't mark that he served personal service, and he didn't mark that, in fact, he had mailed it. Again, an issue that I don't think you can, as a prosecutor, remedy. From a defense standpoint, this rescission should be granted based on the paperwork. And at the bottom, the officer dated it June 2nd. It's clear that that was the date the officer filed it, but again, remember from the preceding page, it was not the date that the officer said he gave sworn report. The Secretary of State, there's going to be a problem here, and I think that needs to be resolved in court before you go to a hearing. The next one. You look at this sworn report was out of Campton Hills, which is a new village incorporated just west of St. Charles, where my office is in St. Charles and Sycamore. If you look at this sworn report, we don't know what happened because the officer didn't mark the box because you refused to submit or failed, didn't mark the box because you submitted to testing conducted, didn't mark the box of an alcohol concentration or any amount of drugs. Interestingly, the Secretary of State confirmed on this. And they looked at it, they didn't send it back as they're supposed to under 11501.1H, where they're to send it back to the officer and say, fill it out. They went ahead and confirmed on it. So what happened in this case was the petition to rescind was granted that I filed based on legal arguments that there's no way the Secretary of State could confirm on anything because this was a fatally defective sworn report until the officer did something. So you want to make sure you look at these sworn reports and see whether or not you can, in fact, file a motion to strike and dismiss. From the defense standpoint, is it legally sufficient? And from the prosecutor's standpoint is, can I save this? And if you can't, concede it, because you gain your credibility and your reputation with the judge by admitting you can't save it. What do? You tell the police officer, next time this is how you do it. Next time this is how you don't do it. And then you gain credibility with the judge, you train your police officer, and then on the next time they will do it.